Hi guys, and welcome to another episode of Atty Vlogger, Law for the Everyday Layman. Today we take up part 5 on the law of sales, and we'll be talking about the obligations of the vendor. Okay, so if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So let's take up the obligations of the vendor. This is only part 1, no? Because the discussion here is very long. So the obligations of the vendor include to transfer ownership, to deliver the thing and its accessories and accessions, to make warranties, to take care of the thing with the proper diligence pending the delivery of the object, pay the expenses for execution and registration of the sale, except of course if there is a stipulation to the contrary, to give the buyer the right to examine the goods, to enter into a contract with a carrier on the buyer's behalf if reasonable under the circumstances, and finally to notify the buyer of the necessity to insure the goods if it is usual to insure such goods. Okay, let's talk about the first obligation of the vendor, which is to transfer ownership. And the rule is that ownership is transferred upon delivery, whether actual or constructive. Okay, now payment does not affect ownership. Why? Because payment goes into consummation and failure to pay is simply a breach which gives rise to the actions of specific performance or rescission. Okay, again, the rule is ownership passes upon delivery. The exceptions are as follows. Of course, if there is a contractual stipulation reserving ownership, no, which is known as pactum reservati dominii. Okay? So, the parties can agree by stipulation that ownership will be reserved until payment of the price. Second exception when ownership does not pass would be the contracts to sell. Okay, I have a long discussion on contracts to sell, but to review, contracts to sell are bilateral contracts which are subject to a suspensive condition. The obligation to deliver and to enter into a contract of sale is subject to a suspensive condition, usually full payment of the purchase price. Okay? Third exception to the rule that ownership passes upon delivery would be the case of sales upon acceptance, trial, approval, or satisfaction. Because in these kinds of sales, the ownership passes to the buyer only when the buyer signifies his acceptance or approval, or he performs an act adopting the transaction, or if he doesn't signify his acceptance or approval but he retains the goods without giving notice of his rejection, and then there is a period set for which he must give a notice, then the period expires, or if there is no period fixed, then upon expiration of a reasonable time. Okay, now these sales on acceptance, approval, etc. are different from sale or return. Okay, because a transaction which is on sale or return, the ownership passes right away, okay, to the buyer, no? In which case, the buyer can revest ownership in the seller by returning the goods within the fixed time or within a reasonable time if there is no time fixed for return. We'll talk about those two transactions more later on. But let's go to the next exception to the rule that ownership only passes on delivery. No? The fourth exception is implied reservation of ownership under Article 1503 of the Civil Code. No? And these happen when the goods are shipped, and then under the bill of lading, delivery to the seller, his agent, or to their order, the seller reserves ownership. Okay? Second is when goods are shipped and under the bill of lading, delivery is to the buyer or his agent, but possession of the bill of lading is still retained by the seller of his agent, in which case the seller reserves possession over the goods. And finally, if the seller draws on the buyer for the price and transmits the bill of lading and the bill of exchange to secure acceptance of or payment of the bill of exchange, but the buyer dishonors the bill of exchange or doesn't honor the bill of exchange, then there is an implied reservation of ownership. Okay? So that's it for the obligation of the vendor to transfer ownership. The second obligation of the vendor is to deliver the thing and its accessions or accessories. Okay? The seller is bound to deliver all the goods and all the accessions and accessories except if there has been a stipulation that delivery will be by installment. Okay? The thing as well as the accessories and accessions must be delivered in the condition in which they were at the time of perfection of the contract. And take note that the fruits, they pertain to the buyer on the day on which the contract is perfected. Okay? In order for there to be a valid delivery, there are just three requisites. There must be identity, the object itself must be delivered. There must be integrity, all of the things and must be delivered for the enjoyment of the buyer in a condition to allow him to see that it is consistent with the purposes of the obligation, and it must be intentional. Identity, integrity, and intentional. No? Now, as to the forms of delivery, we have actual or real, meaning that the control or possession is physically given to the buyer, or we have constructive, no? In which case, delivery is by representation, no, of acts or signs indicative or indicating delivery. In other words, the seller has control, then the buyer must be given control by any of the forms which I will discuss, and there must be intent to give the control to the buyer. Okay? The first method of constructive delivery is the execution of a public instrument. Okay? Now, merely executing a public instrument is enough to constitute delivery, except in the following cases. First, if there is a stipulation that the date of taking of the possession or transfer is stipulated upon by the parties. Another is when the ownership or possession will only be transferred upon payment of the final installment, or if there is a reservation of the right by the seller to use the thing until he has finished gathering the fruits of the thing. Okay? Also, there is at execution, the thing is not in control of the seller, because the execution of the public instrument is only a mere act, because the seller does not have control over it yet, no? And finally, there is no reasonable time given for the buyer to take control, because the law requires that a reasonable time be given to the buyer within which he can take control of the thing subject of the public instrument. Okay? So the first mode of constructive delivery is the execution of a public instrument. Second, we have traditio symbolica, okay? Which is simply by giving a token or a symbol of the thing, such as in the case of a house or a car, by the delivery of the key. Okay? Now we have traditio longa manu, which is by mere agreement, no? Or when the seller merely points out to the thing and says that the thing has been delivered now to the buyer. Okay? So we also have traditio brevi manu, no? Or by the shorthand. Longa manu is longhand, brevi manu is by the shorthand. Okay? In which case, the buyer is in possession of the thing, and then later on he becomes the owner. Okay? Such as in the case where a person is leasing an apartment and then it is sold to him, then he becomes the owner and he continues in possession. The opposite is traditio constitutum possessorium, no? In which case, it is the seller who continues in possession, but he is no longer the owner. Okay? Wherein a seller was formerly the owner of an apartment unit, and then he sold that apartment unit to a buyer, but that seller stays in the apartment, no? And as he is leasing it, no? He is a tenant there. Then in that case, there is transfer of ownership to the buyer, but the seller remains in possession. Okay? Now, when it comes to rights, credits, or other incorporeal things, delivery is made through what we call quasi-traditio, okay? And under quasi-traditio, we can have either execution of a public instrument, or the actual placing of the titles in the hands of the buyer, or in case the seller allows the buyer to make use of the rights, okay? Delivery may also be by operation of law, like when in our discussion on sale by a non-owner. In case a non-owner sells a thing without having title, then he subsequently acquires title. Title will now pass by operation of law to the buyer. Okay? Next, we have documents of title. Documents of title can also serve as a mode of delivery, no? And through these documents of title, the seller is allowed to deal with the goods as if he physically delivered them to the buyer. And the buyer, on the other hand, may take that document as though he actually took possession or control over the goods, no? Now, in case of negotiable document of title, endorsement and delivery operates as transfer of that possession and ownership of the property, okay? Which is covered by the document, no? So, proof of possession or title or control over the goods is there in that document of title, no? It is also an evidence of the authority to transfer or receive on the part of the holder of that document of title, no? And the common kinds of documents of title are the bill of lading, or dock warrants, or warehouse receipts, or kedans, no? When we say bill of lading, this is issued by a common carrier, no? And threefold function of a bill of lading is that it serves as a receipt that the carrier had actually received the goods. It serves as evidence of the contract of carriage, and it serves as a document of title, which is again proof of ownership or possession over the goods. Okay? A dock warrant, on the other hand, is a recognition of title to the goods. Okay? And a warehouse receipt is simply evidence that the warehouseman holds those goods in favor of the person holding the receipt. Okay? Now, when it comes to documents of title, we just have to know that there are negotiable documents of title and there are non-negotiable documents of title. Okay? When we say negotiable documents of title, there is an obligation of the bailee, no, the warehouseman or the person holding the goods, to deliver the goods to the bearer or to the order. Okay? The negotiable document of title may be negotiated either through delivery or through endorsement coupled with delivery. And by whom? The negotiable document of title may be negotiated by the owner or the possessor or the person who has custody of such negotiable document of title. Now, in case of negotiation of a negotiable document of title, these are the following rights which a person may acquire. First, no, he acquires title of the person who negotiated it to him. If the person who negotiated the document of title to the current holder was a thief, the thief has no title, so there is no title which can be passed. Okay? So, the right he acquires is such title as the person negotiating had. That's the first. Okay? Second, he also gets the title of the named person in the document, meaning if it's to order, to a person or his order, then he gets the title of that person or to order, of the depositor or the owner of the document of title. Okay? And finally, the third right that the person gets is he gets automatically the direct obligation of the bailee to hold possession of the goods as if the holder made a direct contract with the bailee. Okay? So it operates as delivery already. No, he just has to get the physical possession of the goods from the bailee, which is different now from a non-negotiable document of title. Okay? It cannot be negotiated because the words by delivery or to order are absent. Okay? Now, in case of a non-negotiable document, no, this may be assigned or purchased by any other person, but it is not negotiated. Okay, there is no endorsement, there is no delivery to bearer, no. And the rights here are as follows, no. The holder, the person who gets that non-negotiable document of title, simply acquires title subject to the terms of the transferor. No, so he does not acquire absolute right, no. He just gets it subject to the terms of his agreement with the transferor. And second, he gets the right to notify the bailee that of the transfer, and that now that the bailee has to hold the goods for him. Okay? In other words, the difference between the non-negotiable and the negotiable documents of title is that the notice of the bailee to hold in favor of the current holder is automatic if it's negotiable document of title, and in non-negotiable there is still an extra step. Okay, the holder still has to notify the bailee that, hey, a transfer has been made and now you have to hold the goods for me. Okay, so in non-negotiable documents of title, there is no automatic delivery. It doesn't serve as delivery, unlike in negotiable documents of title. And furthermore, the most important distinction is that in case of negotiable documents of title, the person negotiating to the holder can be held liable for breach of warranties. No, the breach of warranties here are similar to the warranties in negotiable instruments law, such as the instrument is genuine, there is a right to negotiate, there is no knowledge of impairment of validity of the document, he has a right to transfer the document, and that the goods are merchantable or for a particular purpose. Okay? Now, if you want to learn more about negotiable documents of title or negotiable instruments, I will be coming out with a series on nego soon. Okay? Just wait for it. Okay? Now, let's move on to another mode of delivery. No? There is delivery to the carrier. Okay? Now, the rule in case of delivery to a carrier is that in case the seller is authorized to deliver the goods to a carrier, when we say carrier, a ship, usually it's a ship or airplane, no? Or yung mga LBC or to go, ganyan, those are carriers, no? They are common carriers of goods, no? So if the seller is authorized to ship the goods, then delivery by the seller to the carrier is considered as delivery to the buyer. In other words, the moment the seller gives the goods to LBC, it's considered delivery to the buyer. But that is only a general rule. Okay? Of course, the exception is if a contrary intention appears or if there is implied reservation of ownership, which I have discussed earlier. Okay? Now, there are some terms that you have to know in case of carriage, no? There is FAS or free alongside, no? Which simply means that the seller pays all the charges and bears the risk of loss until the goods are placed alongside the carrier, no? Or the ship, no? FOB is free on board. In other words, it is free to the buyer. He does not pay until the carrier has reached the point of FOB, in which case, at that point, let's say it's FOB on dock, the docks, no? And then, at that point, ownership is already transferred, okay? We also have CIF, or cost insurance freight, no? And this simply means that the purchase price given to the buyer to pay already includes the cost of goods, the cost of insurance, and the cost of freight, which has already been previously paid by the shipper. Then we also have COD, or collect on delivery, in which case the common carrier acts for the seller in collecting the price. Okay? Now, rules as to the place of delivery. Okay? If there is an agreement, then it should be at that place. If there is no agreement, then you follow the usage of trade. If there is none, then it should be at the seller's residence, and in absence of all things, wherever the goods may be found. Okay? Now, in case of delivery which does not follow the place of agreement, then if the buyer accepts it without complaint, no, he is deemed to have waived any action against the seller's failure to follow the terms of the contract, and the buyer must now pay for the price. Okay? And what about the time of delivery? Of course, if there is a stipulation or agreement, we follow that. If there is none, then it should be within a reasonable time, which will depend on the circumstances of the case. Okay? Now, let's discuss this animal called sale on approval, trial, acceptance, or satisfaction, no? This contract is in the nature of an option to buy if the goods are satisfactory, no? The buyer's approval is a condition precedent, okay? Meaning that the sale depends upon the quality of the goods if they are up to the approval or acceptance or satisfaction of the buyer. Okay, so let's just summarize the rules in case of a transaction like this, no? First, the title remains with the seller, okay, until the sale becomes absolute. And when does the sale become absolute? The buyer must express his acceptance, or he either fails to give notice of his rejection, or if the buyer returns the goods, no, in which case then the sale does not happen and ownership is still with the seller. Okay? Second rule is that the risk of loss or damage stays with the seller except when the buyer is at fault or if he has agreed to bear the loss. Okay? Third rule, no, the buyer must give the goods a trial, no? He must test them, no? He must test them to see if they are actually satisfactory or etc., no? And he does not have to give the goods a try anymore if it is evident that the goods will not work as intended. Okay? Fourth rule, no? If there is the period, no? The period within which the buyer must return the goods begins when he has received all of the goods, no? If he's still waiting for some more to arrive, then the period within which he must give notice of his approval or rejection does not yet begin to run. He must have received everything already. Okay? And with that, no, we can move now to sale or return. No, there is a transaction known as sale on return. As I mentioned earlier, no, a transaction sale on return is one where the buyer immediately becomes the owner. Okay? He receives the goods in concept of an owner and he has the option to return it and then revest the title in the seller. In other words, the title passes on delivery to the buyer, so therefore the buyer bears the risk of loss. Okay? The option of the buyer to return does not depend on the quality of the goods, no, because he's already the owner, okay? And the ownership is revested in the seller after expiration of the fixed time and the goods have not yet been returned, or in case there is no fixed time, within a reasonable time, okay? Which again depends on the circumstances of the case. Okay? So again, in case of a sale or return, this one is subject to a resolutory condition. In other words, rights already exist. No, the buyer is already the owner, and if he returns, then the obligation is extinguished. No, but in a sale on acceptance, trial, approval, satisfaction, no, this is subject to a suspensive condition, and that condition is if the buyer approves. No. Sale on return depends on the will of the buyer, while sale on acceptance depends on the quality of the goods, if they are up to the approval or satisfaction of the buyer. No, the sale on return, ownership passes on delivery, and the buyer may revest that or return it to the seller. Okay, while in sale on acceptance or approval, no, the ownership remains with the seller until the buyer has signified his approval. Okay? And finally, in case of sale or return, the risk is borne by the buyer, while in sale on approval or satisfaction, the risk of loss is borne by the seller, following the rule of res perit domino, that the owner bears the loss. Okay? Now, there is another animal called sale on description or sale by sample. And in either sale by description or sale by sample, the goods must necessarily correspond either to the description or to the sample. Okay? And in case the goods do not correspond to the description or do not correspond to the sample, then the buyer has two remedies. No? He may ask for rescission of the contract, no, have it cancelled, and there will be mutual restitution, or he may keep the things and instead sue for damages for breach of warranty because it did not correspond to the description or to the sample. Also, please take note that earlier, those were two separate cases, no, yung description and sample. But it can be sale by description and sample. So in which case, the goods must correspond both to the description and to the sample. Okay? And in which case, if it does not, even to one or both, then again, rescission or breach of warranty and ask for damages. Okay? Now, let's move on to completeness of delivery. No? How do we know when delivery is complete? Let's have it into two scenarios. Let's talk first about movables. No, when we talk about movables, again, these are personal properties like cars, watches, etc. No, in relation to the promise, no, to deliver, no, the quantity of the goods delivered is less. Okay, let's say the seller promised to deliver 15 but was only able to deliver 5. Okay? So, that's the first scenario under movables. What was actually delivered is less than what was promised. Okay? So, the remedies of the buyer in this case, he can either reject the goods, okay, because syempre they're less than what he asked for, or accept those goods. Okay? In case the buyer accepts the goods, there are two rules. Okay? If the buyer accepts the goods with knowledge that the seller will no longer perform his obligation, in other words, the seller will no longer give the deficiency, no? If that happens, then the buyer must pay at the contract rate, what they had agreed upon to be paid, no? But if the knowledge is only after he has accepted the goods, or after consummation, or after he has even disposed of the goods, no? In this case, he does not pay at the contract rate. He can pay less, no? Which is tagged at the fair market value of the goods he received. Okay, so he can pay less. But if he accepts with knowledge of that the seller will no longer perform, then he has to pay the higher contract rate because he's now stopped. No, he accepts it even though it's kulang. Okay, but what if what was delivered to the buyer was more than he asked for, or a larger quantity? No, in this case, the buyer can accept the goods and reject the excess. No, accept and this is sobra, I don't want it. Or the buyer can accept everything including the excess, but he must pay the contract rate. Okay, however, no, if the thing is indivisible, it's not capable of partial performance, then the buyer may either accept it in its entirety, the whole, or reject it in its entirety or the whole because it's indivisible. Okay, and finally, what if the movable is mixed with goods of a different description? Then the buyer may either accept that part and reject the rest, which are different. But if the thing is indivisible, then of course he can accept the entirety or reject the entirety or the whole. Okay, so that's it for movables. No, in case of immovables, there are different rules. Let's start with the general rule. No, if the contract of the sale of land has a statement, no, of the area with a price per unit of measurement or per number, no, like I am selling to you 55 square meters at 100 pesos per square meter. That's the example of that, no? So in case B demands performance, then the seller must deliver everything which is stated in the contract, okay? The scenario again is if the contract has a statement of the area with the unit of measurement, okay? 55 square meters at 100 pesos per square meter, okay? What if the thing delivered, the land or real property delivered is less than the area stipulated, or is inferior in quality, or is different in quality, okay? This case, no, the buyer has two remedies. He can either ask for action quanti minoris, which is a proportional reduction in price. Okay, reduction in price because again, the land delivered was less than what he asked for, no? So it's quanti minoris, proportional reduction in price, or rescission. Okay? But, okay, this is important, no? The buyer can only ask for rescission first if the lock-in area is at least 1/10, okay, of that agreed upon, no? Yung kulang sa area is at least 1/10 of that agreed upon. Or in case of quality, no, difference in quality or inferior quality, then the inferior value or quality exceeds 1/10 of the price. Okay? Just remember that, no? But now, what earlier that was in case of delivery of less. What if what was delivered was greater or more, no? Then in this case, the buyer can accept the thing and reject the excess, okay? In his other option would be to accept the whole, even in the excess, and he will just have to pay the contract rate, okay? What about sales for lump sum or sales of two or more parcels of land for a single price, no? The rules for those two scenarios are the same, no? In case the land sold is greater than or less than, no, may sobra or kahit may kulang, there will be no increase or decrease of the price. In other words, if what was delivered is actually more than what was advertised or offered, then there should be no increase in the price. But if it's less, also no decrease in the price. Again, that's the rule in case of a lump sum sale or two or more parcels of land for a single price, okay? But there is a qualification to that rule, no? What if the contract of the parties gives an area, no, like let's say 55 square meters, and states the boundaries as well, which of course the boundaries are necessary, no, so that you will know the identity of the property being sold, okay? So in that case, no, the seller must deliver everything which is contained within the boundaries, even if it exceeds the area agreed upon in the contract. What if the seller fails, no, or refuses to deliver everything? Then in this case, the buyer is entitled to either ask for action quanti minoris or proportional reduction of the price, or to ask for rescission, okay? Now, all those actions earlier, quanti minoris and rescission, they have a prescriptive period, and this is 6 months. No, these actions must be filed within 6 months from the date of delivery. Okay? Okay, now finally, the last thing we will talk about on the completeness of delivery and delivery in general is when the seller is not bound to deliver. Okay? First, of course, if the buyer has not paid the price. This scenario contemplates an absolute contract of sale, which has reciprocal obligations, no? Meaning, it follows the rules on reciprocal obligations that when one party is able to comply and the other is not, then this party is in breach. So the seller is not bound to deliver until there is also at least an offer to pay the price, no? to that example is accepted the situation where there is a period fixed for payment, in which case respect the period. Okay? Second scenario, when the seller is not bound to deliver the thing. Okay? What if there is no period for payment fixed, no? If there is no period for payment fixed, then we will not know, the seller will not know when he will be receiving the consideration. Okay, in such case, since he does not know when he will be paid, then the seller is not bound to deliver the thing. Okay? Then we have the last scenario, no? If there is a fixed period within which the buyer must pay, but the buyer has lost his right to the benefit of the period. Okay, we have discussed this in obligations and contracts under the topic of obligations with the period. But just to review, no, the debtor loses the right to make use of the period in case he is insolvent after the obligation, and unless he gives guarantees or other securities, no. Second case, he loses the benefit of the period in case he has given guarantees or securities which have been lost or impaired, no. Third is when there is a violation of any undertaking to which the creditor has agreed to the period, no? Fourth is when the guarantees or securities which are offered are impaired but does not give ones equally satisfactory. And finally, when the buyer attempts to abscond, no, or leave the country to evade payment of the debt or obligation. Okay, so that's it for the first part on the obligations of the vendor, no, or the seller. And I hope you'll stick around for the next video on double sales. I'll be talking about double sales. Okay, so thank you, and I hope to see you soon. Bye.